What are tenancies? Are there any special tenancies for married people? What are the differences between the tenancies? Are there any occasions where a tenancy could be changed? These are some of the questions and others that we're going to talk about today. I'm Michael Miller. I'm a partner at Cole Miller PLLC. We're a family law firm located in Vienna, Virginia, serving primarily the Northern Virginia area. I analyze challenges and I find affordable solutions for families and their family law needs. So when it comes to owning property, and you can have accounts, there's what's called a tenancy as to how the accounts are held. The three tenancies we're going to talk about today are what's called tenants in common. The second one is joint tenants with rights of survivorship. And then the third one is called tenants by the entireties. And this is the special one that's only available to married people. So the tenants in common is the lowest level tenancy with the least protections and least restrictions on it. It's the one that if two or more people own property, that's the tenancy that's presumed. This tenancy can be created by anyone. So you don't have to be related. You don't have to have any special relationship to each other. Two people can go together and create a tenant in common. Tenants in common own an undivided percentage interest in the property. So two tenants own 50% each, and so forth. A tenant may sell his interest without approval of the other tenants. So now if two people go into business together or three people go into business together, one of them wants to sell their interest, they can, and now the remaining tenants have a new tenant on their account that they're in business with. So might be something that you want to put in your partnership agreements or business formation agreements that would limit somebody deciding to put you in business with someone else that you may not want to necessarily be in business with. A judgment creditor of one of the tenants could petition the court to divide the property and collect judgment from that tenant's share. So again, the other tenants are at risk that if one of their tenants in common were to be subject to some sort of lawsuit and have a judgment levied against them, that the judge could order that a portion of the business or a portion of the asset be liquidated to satisfy that judgment, which could have adverse consequences to the other tenants there. If one of the tenants dies, their interest passes through their estate. So again, you may find yourself owning property with someone you may not necessarily want to. And, the scenario we'll talk about here with regard to tenants by the entireties is, the worst scenario would be a married couple that owns their house by tenants by the entireties. They get divorced. We'll talk about by operation of law, the tenants by the entireties is converted to tenants in common. Then the one ex-spouse remarries, and then that ex-spouse dies. Now, the current wife or current husband is now a tenant in common with the ex-spouse, probably not the two people that want to be owning property together. A deceased tenant can pass their interest by will. Otherwise, it goes through intestate succession. So again, if you want to have that tenancy, you run the risk of if one of your co-tenants dies, that you end up in ownership with someone that you may not care to do that. The good news is that upon divorce, there is no change to the tenants in common, and a tenant in common may partition or petition to partition the assets. So that is the tenant in common, the lowest level sort of tenancy there is. Then the next level up above that is what's called the joint tenants with rights of survivorship. And a joint tenants with rights of survivorship, it has to be specified in the deed. It can also be created by anyone. In this instance, the tenants own an undivided percentage interest in the property unless otherwise specified. But now you have a limitation in that the tenant can only sell their interest with the approval or consent of the other tenant. So now you have some limitations on how the interest can be sold or transferred. A judgment creditor of a joint tenant with rights of survivorship can petition the court to divide property and collect the judgment from the tenant's share, similar to the tenants in common. But the one big difference now that pops up here is the rights of survivorship. If the tenant dies, then the interest passes to the surviving tenants by common law rights of survivorship if it's set out in the deed. A deceased tenant cannot control the disposition of their interest by will, because the rights of survivorship say the ownership goes to the other tenants. You can't contradict that with a will. A joint tenancy with rights of survivorship is automatically converted to a tenants in common or tenancy in common pursuant to Virginia Code 20-111, and a joint tenant with rights of survivorship may petition to partition the property. So you have some added protections and some limitations here. The one value is with the rights of survivorship. So as we'll talk about here in a second, with regard to tenants by the entirety, and as we've already talked about, Virginia Code 20-111, the tenants by the entirety is converted to tenants in common. Tenants in common, lease protections, the ex-spouse can alienate their portion and so forth. And so what you could do is have the ex-spouses, if they're going to continue to own the former marital residence, have that retitled as joint tenants with rights of survivorship, so that if the event one of the tenants dies, then the new spouse doesn't become the joint owner with the ex-spouse. Our highest level tenancy is what's called tenants by the entireties. This also has rights of survivorship. The originating documents must state that it's a tenants by the entirety. So you would look in the deed, and somewhere in the deed it would say that the two spouses purchase the property as tenants by the entireties. In this instance, the notion is the marital relationship is the single entity, and it's the marital relationship that owns the entirety of the tenancy. This can only be created by spouses, so there does have to be a marriage in order to create this tenancy, unlike the other two tenancies that could be created by anyone. As I said, the view here is that the married couple is the one entity, and it's the married entity that owns the interest in the asset. A spouse may not sell their interest in the property without destroying the tenancy by the entirety. So it's an all or nothing proposition. Both spouses have to agree if they want to sell the property. And so, this is the problem we run into in the course of a separation is one spouse may want to sell the property, but they can't because of the other spouse is a co-owner and can prevent the sale from going through. A special feature of this tenancy, the tenants by the entireties, is that a judgment creditor may not collect a judgment from the entirety property. So if one spouse is sued and they have a judgment against them, they can't have the property liquidated to satisfy that judgment the way that they could for tenants in common and joint tenants. Because of the rights of survivorship, the surviving spouse automatically, by common law right of survivorship, becomes the owner of the property upon death of one of the spouses. Consequently, a spouse cannot dispose of their interest through will because it's already been addressed with the rights of survivorship. As we talked about previously, again, Virginia Code 20-111 says that upon entry of a divorce, the tenants by the entireties is converted down to tenants in common. So this is, one of the reasons when you look at Virginia Code 20-107.3 that the court wants to, grant the divorce and do the property division and get the orders and the property disposed of because of the changing nature of the property, where you're going by this protected tenancy by the entireties, dropping down to tenants in common. So you don't want to grant the divorce and then come back a year or more later, because in the meantime, there's the risk of one of the spouses predeceasing the other one, judgment creditors getting involved, and things like that. And a tenant by the entirety cannot petition to partition the property because again, the property is owned by the marital relationship, and the entirety of the property is owned by the couple. So there's no seeking to have the property partitioned. So quick touch there on the three types of tenancies: tenants in common, joint tenants with right to survivorship, tenants by the entireties, also with rights of survivorship. The tenants by the entireties we find with married people provides protections from creditors, provides the rights of survivorship, and one spouse cannot sell their interest without the other spouse's consent. All good protections for the other spouse, but upon a decree of divorce, that's converted to tenants by the entireties. That's now exposed to creditors to sale and transfer and partition and things like that. So something to keep in mind as you're going through your divorce process is to watch the tenancies.